What's up? It's your favorite attorney Allie Booker. You already know what time it is. We're teaching. Let's go. Classroom and court is now in session. They wrote me and they said, let me get my board together. Okay? You already know how this goes. And guys, you need to always be able to move on your own, regardless of whether or not you have an attorney at your disposal. Attorneys are expensive. We bill for meetings. We bill to talk. There are many of the times that you all will not be able to get a hold of us at 10 o'clock at night, 3 o'clock in the morning, and at different times when you're actually going through this. So the purpose of this is to teach you how to move until you can get to your attorney. Okay. They wrote me and they said, my ex-spouse broke into my home. Recently, I went through a divorce. In the divorce, I was awarded the house. My ex was not to step foot into my property anymore. About 3 weeks later, my ex climbed through a window. I have video footage of the incident. I would like to press charges in event and to prevent this from happening again, but I've yet to receive cooperation from the police department. Although the court document was dated and issued the day we left the hearing, the judge didn't sign the document for a few weeks. The police are saying the court document is only valid when the judge signs it. What are my options? Should I hire an attorney? And if so, what type of attorney would be best? Order, okay? You are already in a divorce, okay? And there has been a petition. But there are times, in an order, but there are times where enforcement of that order cannot occur, okay? A court's order does not take effect per se until the judge has signed the order. And that's on the criminal side. So the police cannot do anything because they don't see a court order for the date that he broke into your home. Okay? However, the date that the judge decided that he can no longer be in your home is the date that that judge is going to go by. So what you do is you get the record, okay? There's always a record of a proceeding. And there's always a court reporter, okay, that's either typing or talking into this weird-looking device. What they're doing is writing down everything that the judge has said and everything that the judge is ruling. Once a judge utters something off of their tongue, it is in order. See, we can't hide behind the fact that the judge did not sign the order because we are not the police. So the police were not present at that court date. So they have to go on the evidence that they see. And they see a enforcement action that they cannot enforce because of the date, okay? So although the police are out, this record is what we are going to need, okay? And the date that the judge uttered it out of her mouth with his or her lips are the dates that that particular judge goes by. So what you need to file is an enforcement action. But you're going to need to get the record from the person that typed it, proving that this gentleman knew, okay, that he was not allowed to be in that home at the time and the day in which he entered. So if that record says that the court proceeding was held before the day that he broke into the home and he was present, because the court report is going to write that he was present, then guess what? That is automatic, direct evidence that he knew he was not supposed to be in that home. Therefore, the enforcement is going to stand and you can hold him in contempt of court. Because when this gavel bangs, it's written. And whether or not it's signed doesn't mean anything. Because we're not going to take away the authority of a judge to say what they mean and mean what they say. So on the date that it has been uttered by that judge, although the judge has not signed it, if that person is located in that court and they heard her say that, that's it. They're going to be held to that order. So go back to that judge. Go back to that judge's court. You may not be able to get criminal charges, but you can darn sure get him held in contempt of court. And then through the judge that actually rendered that order based on what they said and the date that it came out of their mouth. Because I'm pretty sure it was clear that he was not allowed in that house on the day of court. And what he's banking on is that nothing can be done to him because the order wasn't signed, and that is not necessarily so. And I tell my clients that just because there's no order written does not mean you cannot be held in contempt of court. The judge that uttered it knows whether or not you were present, because that lady that was typing, the beautiful lady in the corner, said that you were there. And if it's clear on its face exactly what the judge said and you were present, then guess what? You heard that judge. And if you heard that judge, then guess what? You are put on notice and you are not to violate what a judge says. So just because something is not written down by a judge does not mean that you cannot get in trouble for it with that judge. Take them back to that court. Next case.
Biggest time I made that call. I'm locked up and facing charges. Who gon' fight these cases for me? I called Booker Law Firm. They got the job done. They were right there for me.
For more information, contact the Booker Law Firm at 713-292-2225.